Good evening, everyone. My name is John Rubiner, and as the chair of this year's Litigation Awards dinner, it's an honor and a privilege for me to welcome you to one of the Beverly Hills Bar's most prestigious annual events to acknowledge true giants in our litigation community here in Los Angeles. This year, we're recognizing two awardees who are longtime members of our community. Justice Audrey Collins of California's 2nd District Court of Appeal and Kelli Sager, a partner at Davis, Wright, Tremaine. Both Justice Collins and Kelli have spent decades not only working in the law, but striving to make our profession and our society a better place. It's a special honor for me to be the chair for tonight's event, and I'm humbled that I get to share this lectern with such two amazing lawyers and people. In the past, our award for judicial excellence has been awarded to California Chief Justice Ronald on the eve of his retirement, and for whom the award is now named. Presiding Justice Norm Epstein of the California Court of Appeal, United States District Judge Christina Snyder, Judge Michael Nash, longtime supervising judge for the Los Angeles Juvenile Court, Presiding Justice Arthur Gilbert of the Court of Appeal, Judge Stephen Reinhart of the Ninth Circuit Court of Appeal, Justice Lori Zelon of the California Court of Appeal, and last year to Judge Lee Smalley Edmond, Presiding Justice of Division 3 of the 2nd District California Court of Appeal. Tonight, we honor Justice Audrey Collins of the California Court of Appeal. After graduating from my alma mater, the UCLA Law School, Judge Collins served as an assistant attorney of the Legal Aid Foundation of Los Angeles, and in 1978 became a deputy district attorney in the Los Angeles County District Attorney's Office. In 1987, Justice Collins was promoted to head deputy at the Torrance Branch Office. The following year, she was appointed as the assistant director of the Bureaus of Central and Special Operations. In 1992, she was named the assistant district attorney and a deputy general counsel in the Office of the Special Advisor, where she served as counsel to the Los Angeles Police Department Board of Commissioners. 2 years later, President Bill Clinton nominated Justice Collins for a seat on the United States District Court for the Central District of California. She served as chief judge of that court from 2009 through September 2012. Speaking for Justice Collins tonight will be her brother, the Honorable Bruce Bodie, who currently serves a misdemeanors trial court in the Southwest Judicial District in Inglewood. Presenting Justice Collins with the Ronald M. George Award will be Justice Lee Smalley Edmond, Justice Collins' colleague and friend on the Court of Appeal and our 2018 award recipient. We'll then turn to the Excellence in Advocacy Award, given each year to an outstanding litigator from our Los Angeles community. In the past, we've honored Roman Silberfeld, head of the Los Angeles office of Robbins Kaplan, Tom Girardi of Girardi and Keys, Marshall Grossman of the Los Angeles office of Orrick, Brown Green, Brole and Wheeler, Tom Nolan, who's now at Latham and Watkins, Morgan Chu of Irela Manila, Bill Chernoff of Chernoff, Biddart and Echevarria, and last year to Dan Grunfeld, a powerhouse litigator in this community, formerly at Morgan Lewis and the former president of Public Counsel. And I'm proud and honored that tonight we honor our first woman recipient of the award, Kelli Sager of the Los Angeles office of Davis, Wright, Tremaine. While it's historic that Kelli is our first woman honoree, let me be clear, we selected Kelli on her merits and the work she has done as a giant of First Amendment law in our community. To be honest, I was hesitant to point out her gender, although it's obvious. That she happens to be a female is simply something that helps make this occasion a little more special. But honoring Kelli, the person and the lawyer, is what tonight is about. Speaking for Kelli will be Jeff Glasser, General Counsel of the Los Angeles Times and the San Diego Union Tribune, and Carlene Galler, a former Assistant General Counsel of the Los Angeles Times, who opened her own firm and serves up counsel to Jassy, Vic, and Carolyn. The Excellence in Advocacy Award will be presented to Kelli by last year's honoree, Dan Grunfeld. This will be an exciting and historic night as part of the Beverly Hills Bar's Year of the Woman. However, mostly we're honored by you, our audience of Los Angeles' finest lawyers, litigators, and friends. For more than 80 years, the Beverly Hills Bar Association has been filled with the finest lawyers and judges in the country. We're known nationally for our advocacy, our commitment to social justice and the rule of law, as well as our commitment to the profession. As a result, we are now 6,000 strong and growing, and will continue to do so. Thank you for supporting our events and for sponsoring our many activities. We have amazing sponsors tonight, as you see in your programs, and I ask you to join me in thanking our sponsors for their help tonight. It's now my honor and privilege to introduce my friend and the Beverly Hills Bar Association's president, LaVon Lawson. In addition to her work for the bar and her friendship with the many former bar presidents that are wandering this room, LaVon has a tax law practice at her own firm, the law offices of LaVon Lawson. LaVon counsels and represents businesses and individuals in tax controversies and litigation matters. She handles federal and California state income, employment, and transfer tax issues, and her practice includes matters involving international asset and account reporting. LaVon holds a bachelor's degree in economics and in English from Stanford University, a JD MBA from Duke University School of Law, and the Fuqua School of Business. Ladies and gentlemen, please join me in welcoming Beverly Hills Bar Association President LaVon Lawson.
Good evening, everyone, and welcome. It's wonderful to see you all here. It's just a delight, and this is truly a special evening for me. On behalf of the Beverly Hills Bar Association Board of Governors, it is a delight and an honor to be able to congratulate our esteemed honorees, Justice Audrey B. Collins and Kelli Sager. I'm looking forward to the evening, and so I just want to move this along and introduce our CEO and get us forward to dinner so we can hear about our honorees as soon as possible. I'd like to introduce now our CEO and Mark Steenberg, who is former president of the Beverly Hills Bar Association. Mark has been the CEO of our foundation and our association since 2004. A former entertainment attorney, Mark has also been the chair of our entertainment section. So again, enjoy your dinner, enjoy your time. I'm looking forward to a delightful evening. This is a personal, special evening for me. And again, thank you to our honorees. Thank you to our people who are here to support our honorees. Thank you to our sponsors.
I don't want to interrupt anyone's enjoyment of their salad. Thank you, LaVon. Thank you, John. Thank you to the terrific dinner committee for the litigation awards this evening. We are delighted that you all are here to help the Beverly Hills Bar Association Litigation Section present its 9th annual litigation awards dinner, honoring Justice Audrey Collins and Attorney Kelli Sager. We thank our honorees, their families, their friends, their firms, their colleagues, and all of our distinguished guests for helping to make this evening so special. It is also my special privilege to announce that, as is befitting the recipient of our litigation awards, we are pleased to welcome Audrey and Kelli as members of the Order of Distinguished Attorneys, BHBA's highest level of membership. Congratulations to you both. The Beverly Hills Bar Association is rightly proud of our over 88 years and well-recognized history of activism and accomplishments, serving our members, leading our profession, and advocating for justice in our community. Finally, as we all know, these productions do not happen by themselves. So in addition to the work of our Litigation Awards Dinner Committee, it is with deep appreciation and much affection that I acknowledge the hard work and dedication of our amazing and incredible Beverly Hills Bar Association staff, I'd ask that you join me in thanking them. A wonderful program, along with the presentation of the awards, awaits us. But first, I want to also thank the team here at the Four Seasons Hotel, the cook staff, and the wait staff, and I invite you to enjoy a delicious dinner. We'll see you in a little while. Thank you.
I want to welcome you all to an extraordinary evening where we're honoring not only two wonderful legal minds, but even more importantly, two extraordinary people, Justice Audrey Collins and Kelli Sager. As lawyers, we often have the chance to help make changes in our clients' lives, whether that's assisting them through a transaction, helping them with a will or estate plan, or shepherding them through the often complex and sometimes harrowing process of litigation. We tend to help our clients one at a time. And as lawyers, seeing the impact that we can make on our clients is not only satisfying, but it helps to ensure an elusive concept that we as Americans hold dear, the concept of justice and the rule of law. For most of us, we study the Constitution in law school, but we don't deal with it on a daily basis. That's not the case with our honorees tonight. As a judge, Justice Collins grapples with justice on a daily basis. First as a judge on the United States District Court, and more recently as an appellate judge. And as anyone who's practiced in our federal district courts will tell you, it can be an intimidating atmosphere. I recall one status conference I had in front of Judge Collins many years ago when she was a judge in the trial court. And while I was waiting for my case to be called, she was hearing a status conference on another matter. At that moment, a lawyer rushed into the courtroom, pushed aside the litigant standing at the lectern, and made his appearance. And after doing that, he looked to his left and he looked to his right and realized he didn't know any of these people. And he then realized he had made a pretty big error. And he ran into the wrong courtroom and interrupted a hearing in front of a federal judge. The lawyer looked distraught, fumbled an apology, and started to leave, and Justice Collins stopped him and interrupted him. And at that moment, I, sitting in the audience, feared that Justice Collins was going to berate him for interrupting the proceeding, or make some comment about his lack of professionalism by pushing the lawyers. And many of the other judges in other courtrooms in the district court here would have been a very bad experience for that lawyer. Instead, Justice Collins smiled and said, "You're always welcome to come to visit me in my courtroom. Come on back sometime." She diffused a tense situation with a touch of humor and made everyone in the courtroom, including those of us just watching it, breathe a little easier. Kelli Sager also deals with the Constitution in her everyday practice of law. As you'll hear today, Kelli is one of the country's preeminent First Amendment litigators, and she ensures the press has access to information and that reporters can cover the news. When the press needs a lawyer to help sure the government complies with the public's records request, to protect their reporters from defamation claims, or to otherwise protect the freedom of the press, they call Kelli. And Kelli successfully comes through for the press time and time again. It's become fashionable in some circles, though I suspect not in this room, to make fun of the press and to describe the press as our country's enemy. In Kelli's hands, the press is certainly not the enemy of our society, but instead a vital cog in what makes our democracy run. To anyone interested in the First Amendment and holding our local, state, national, and even international leaders to account, the idea that the press is the enemy of the people could not be further from the truth. I know Kelli, and I'm proud every time I'm reading an article in the press and I see that their press is seeking the records from somebody or defending a defamation claim, inevitably somewhere in that article there's a reference to Kelli Sager with a quote about the importance of ensuring a free press in this country. Justice Collins and Kelli Sager exemplify the very best qualities of our profession, the very best of practicing law and judging the right way, with dignity, professionalism, and respect. Justice Collins and Kelli Sager are giants in our profession, and I'm so honored that I'm able to share this event with them. In addition to hearing about Kelli Sager and Justice Collins, you're also going to be able to hear from them. You'll hear their thoughts, not only in thanks for the awards, but for the law, the profession, and ultimately for our society. So let's get started. I'm pleased to introduce Judge Collins' brother, Judge Bruce Brody. He currently serves in a misdemeanor trial court in the Southwest Judicial District, Inglewood Courthouse. Prior to going on the bench, Judge Brody was the Chief Deputy of the Los Angeles County Alternate Public Defender's Office. Judge Brody attended Howard University and received his law degree from Southwestern Law School. He's lectured on many legal topics, including how to give an opening statement and closing argument, trial strategies, and how to manage multi-defendant death penalty cases. He's received numerous honors and awards, too numerous to mention, but most importantly today, he's here not just as a judge, but as a brother. Judge Brody.
Ms. Lawson, Mr. Rubiner, Mr. Steinberg, Ms. Sager, Justice Edmond, Justice Collins, honored guests, ladies and gentlemen, good evening. I rise this evening to talk about someone who came from a small town outside of Philadelphia called Yeadon, an individual who went on to Howard University, moved to Los Angeles, attended law school, became a public servant in the county criminal justice system, and then went on to the bench as a judge. But enough about me. I borrowed that joke from Judge Peter Espinosa with his permission. As you know, Justice Collins is my sister. Many of you know of her storied career, but what you don't know is that she has been my role model and inspiration for over 60 years. As Justice Collins' brother, I can say that public service is literally and figuratively in our DNA. Our grandfather, Reverend Furman L. Brody Sr., was born into slavery in 1856, but became a learned Presbyterian minister. After breaking the barriers and bonds of slavery, Reverend Brody attended public school in 1878 at 22 years of age and graduated in 1883, becoming the first male graduate. Reverend Brody began a tradition of public service in our family that has continued uninterrupted for over 130 years. Reverend Brody famously gave each of his 11 children, including our father, Dr. Furman L. Brody Jr., one piece of advice: find a profession where you can make a living and serve the people too. Our father worked as a dentist in Chester, Pennsylvania for over 50 years. Chester, at the time he opened his practice, was a thriving metropolis with a great deal of industry. Many African Americans came to Chester, having participated in the Great Migration from the South to the North to escape the horrible conditions of the Jim Crow South. After World War II, plants began to scale back their operations, and many of Chester's African American residents lost their jobs. A number of our father's colleagues and friends decided to move their practices to Philadelphia, where they could have a more sustainable and lucrative practice. Our father refused to move, however, even as he watched Chester decline into a poor and impoverished city, because he remembered the words of his father all those years before, and serve the people too. Like Justice Collins, our brother, Furman L. Brody III, who died quite young, also heard and heeded our grandfather's advice and chose a profession as a social worker. His last position was assisting individuals with HIV to find housing in Philadelphia when many landlords did not want to rent to individuals who were afflicted with HIV. Equally, if not more important, there were many exceptional women in our family who confronted and overcame the challenges of racism and sexism, blazing a trail for Justice Collins' success. Our paternal grandmother, Annie Pierce Brody, bore 12 children, 11 of whom survived. Annie was an extraordinary woman in her own right. In addition to raising 11 children, she also helped Reverend Brody with the teaching at Kistler Academy, where he was the principal. Our maternal grandmother, Rachel Kennedy Mosley, graduated from Norfolk Mission College before marrying Ernest Mosley, who was a prolific reader. Rachel, in fact, was a member of the founders group of Norfolk State University. Unfortunately, Rachel had a stroke at a very young age and lost the use of her right hand. Undeterred, she taught herself to write, cook, and sew with her left hand. That determination and courage was clearly passed on to her granddaughter, Justice Audrey Collins. Our mother, Audrey Mosley Brody, was a remarkable woman. Audrey was born in Norfolk in 1915. Audrey attended the segregated schools in Norfolk and graduated as valedictorian of Booker T. Washington High School at the age of 15. Like mother, like daughter, Justice Audrey Collins also graduated as valedictorian of her high school class. Both Audreys attended Howard University, and both Audreys graduated as valedictorians of their respective graduating classes. Now, I know you're probably waiting for the punchline about me, but I did not graduate as valedictorian in high school or college. Our mother, who could read more than 100 pages an hour and had a near photographic memory, passed on her love of reading to Justice Collins. I too followed my mother and sister to Howard University. I followed Justice Collins to Los Angeles, to law school, into public service, and on the bench. In truth, I have been chasing Justice Collins and trying to equal her accomplishments for over 60 years. And while I will never catch her or achieve what she has achieved, there is great value in aspiring to equal those accomplishments. Proudly, I have followed Justice Collins' lead and emulated her in all aspects of my professional life and conduct. Justice Collins has blazed many trails, set a high bar of excellence, and has done so with integrity and principle. And the icing on the cake is that she is a really, really nice person, and I love her dearly. I know that Justice Collins has made our grandfather, Reverend Brody, and our parents proud in all that she has done. Justice Collins approaches her cases with an unbiased, thoughtful, and fair manner, with respect to all who come before her, as your tribute recognizes. Justice Collins clearly followed Reverend Brody's advice and fashioned her career in a manner where she could make a living and serve the people too. Like Reverend Brody, Justice Collins has broken through many barriers and shattered many ceilings. I wish Reverend Brody, the former slave, could be here with us tonight to see his granddaughter, Justice Audrey B. Collins, receive this prestigious award. He would be astonished and oh so proud. Thank you.
sorry, you have to go next. So Justice Lee Smalley Edmond, who's going to soon speak, was appointed by Governor Jerry Brown and sworn in as presiding justice of Division III of the Second Appellate District of the California Court of Appeal in January 2015. During her prior tenure as a judge on the Los Angeles Superior Court, she served as the first woman presiding judge of that court. Justice Edmond has served on the California Judicial Council and is chair of the Judicial Council's Civil and Small Claims Advisory Committee and on the boards of many legal service organizations, including the Legal Aid Foundation of Los Angeles, the Alliance for Children's Rights, Intercity Law Center, and the Constitutional Rights Foundation. And she served on the board of the Los Angeles County Law Library. Ladies and gentlemen, to present the Ronald M. George Award for Judicial Excellence to Justice Audrey Collins, please join me in welcoming last year's honoree, Justice Lee Smalley Edmond, to present the award.
Thank you, John, and thanks again to John and Levon and Mark Steinberg and the Beverly Hills Bar Association for sponsoring this wonderful event. And you are all to be congratulated on your choice of awardees this year. Kelli, congratulations on this well-deserved honor. Excellence in Advocacy is certainly an appropriate award for Kelli Sager. We love having Kelli come argue to the Court of Appeal, and you are always welcome in Division III. And I am particularly honored and delighted to have the opportunity tonight to present the Ronald M. George Award for Judicial Excellence to my good friend and colleague, Justice Audrey Collins. Audrey has been a leader in our legal community for as long as I can remember. On a personal note, I first knew of Audrey when she was the head deputy in the district attorney's office, the first African-American woman to hold that position. Then she became an amazing federal court judge, appointed in 1994 when I was still in private practice. But I feel like I first really got to know Audrey and came to think of her as a friend when she was the chief judge of the Central District at the same time as I was presiding judge of the Los Angeles Superior Court. In those roles, we were often asked to speak together and give what Audrey has described as the standard state of the courts, send help and resources speech. Well, unfortunately, this was 2011 and 2012, and we needed a lot of help. Poor Audrey had to sit through interminable presentations about the LA Superior Court's budget cuts, courtroom closures, layoffs, and the like. And as I recall at that time, she also had many unfilled vacancies at the federal court that were causing extreme workload problems for the judges on that bench. We were quite a pair. I guess misery loves company, and we became fast friends during that period. Everyone agrees she was a great chief judge and a superb leader of that court. She skillfully dealt with the challenges confronting the court in a thoughtful and measured way. She was always upbeat, was a tremendous consensus builder, and worked tirelessly to serve all the stakeholders in improving the operations of that court. Her legacy at the federal court includes 2 programs dealing with criminal justice reform, a diversion program, one of the first federal programs of its kind, and a reentry program known as STAR, short for Substance Abuse Treatment and Reentry. She was frequently honored for her many successes, and when she stepped down as chief judge, I assumed she was only a short time away from taking senior status on the federal court and a life of leisure. But of course, I should have known better. Audrey has far too much energy for that. Imagine my surprise and pleasure when Governor Jerry Brown in 2014 announced that he was appointing the 2 of us to the Court of Appeal on the very same day. Since then, I have been blessed to have Audrey sitting literally down the hall. I can wander into her office and talk to her about anything, and I do. I consider that to be a true gift. And she has helped organize a lunch with justices from other divisions around the Court of Appeal in our conference room once a week. So for those of you who think we don't ever talk on the Court of Appeal, we do, at least once a week. All thanks to Audrey. And just a bit of trivia, something you all may not know, she is an incredible movie buff. Her chambers are filled with Audrey Hepburn memorabilia, and she can always be counted on for the best movie and television recommendations. I have a long list of movies and TV shows that I'm going to watch someday, at Audrey's recommendations. Audrey always had a reputation for being an incredible jurist on the federal court. But for those of you who have followed her work on the Court of Appeal, it is not surprising she is receiving this award. To date, she has signed off on more than 1,200 decisions while on the Court of Appeal. And I think it's fair to say she has just begun to place her imprint on the rule of law in California. Throughout it all, she has become one of the most accessible and warm jurists, not only in dealing with her colleagues, but also with the lawyers and litigants appearing before her. She promotes civility by her example and rulings. The Ronald M. George Award for Judicial Excellence recognizes an outstanding member of the judiciary whose work and career have significantly improved the administration of justice and raised the standards and integrity of the judiciary throughout the state. The award honors a judicial officer who leaves a legacy of accomplishment, innovation, and success with an indelible long-term impact. That's Audrey Collins, who, I will add, is the first African American to receive this award. Please join me in welcoming and congratulating Justice Audrey Collins.
Good evening. I'd first like to thank Bruce for that glowing introduction and Lee for her gracious remarks and presentation. I don't recognize myself in any of it, but it was wonderfully sweet and kind of them. President Levon Lawson, Chief Executive Officer Mark Steenberg, and John Rubiner, Chair of tonight's dinner, thank you so much for all of your help in organizing this and helping me to prepare for this wonderful event. It is a great honor to receive the 2019 Ronald George Award for Judicial Excellence. I first met Chief Justice George when I was the grand jury legal advisor for the LA County DA's office, and he was the presiding judge of the criminal courts. Judge George often provided me with sage advice when legal issues arose with the grand jury. Congratulations to Kelli Sager. You know, Kelli often appeared before me in my courtroom and district court on behalf of clients, including the Los Angeles Times. She was always articulate, well-prepared, and courteous to opposing counsel, which is very important to me. I think both Kelli and I will talk about access in one way or another. I'd like to focus on access to and diversity within the legal profession. I'd like to start with an area in which access and diversity have been hardest to achieve: partnership in big firms, then briefly discuss two positive areas: a relatively new program for improving access to law school, and a real bright spot, the California judiciary. A year ago, the National Association for Law Placement provided results of its research spanning 25 years, from 1993 to 2017. First, the percentage of associates, and of course associates lead to being partners, who are attorneys of color has increased at least some every year, although it still lags behind the percentage of attorneys of color who graduate from law school. Although that's good news, the picture is mixed. The percentage of associates who are women peaked in 2009 and has actually decreased in 5 of the 8 years since. In 2017, the percentage of women associates was below the 2009 level. And the number of African American among associates peaked in 2008 and unfortunately has been followed by a 7-year decline. Most growth in the associate ranks among attorneys of color is represented by Asian American and Hispanic American lawyers. But the partnership ranks remain overwhelmingly white and male. They say a picture is worth 1,000 words, and unfortunately, most of you aren't going to be able to see this picture, so I'm going to have to tell you the story. But a January 27th, 2019 article in the New York Times called "Elite Law Firms All-White Partner Class Stirs Debate on Diversity" shows a picture of their 12 new partners, 11 of whom are white males and 1 woman down at the bottom right. The picture generated an open letter signed by general counsels at companies including Lyft and Heineken, calling on firms to reflect the diversity of the legal community or risk losing business. The week after it was posted, the image was taken down. Paul Weiss said it regretted the gender and racial imbalance of its 2019 class, calling it an outlier. And in fact, that firm is more diverse in terms of women and attorneys of color at the partner level than most of its peers. 23% of its partners are women, compared to 18% across the top 200 firms. Still, this reflects a broader pattern and problem. The share of partners who are women and lawyers of color is much smaller than the number reflected in the ranks of associates, or, of course, those starting law schools. It is serious enough that Theodore Wells, an African-American partner at the firm, has stated, "I fear that African-American partners in big law are becoming an endangered species." Last week, I went to my personal experts on how women lawyers experience life in big firms. My 3 research attorneys, all of whom are women. All formerly worked for firms, 1 for less than a year, 1 for 8 years, and 1 for 12 years. They reported that the work versus rest of life balance is, well, out of balance. One attorney had just completed a prestigious 2-year appellate court clerkship. She joined a national firm, but not the LA office. Although it had an appellate office, she was assigned to, or as she put it, sucked into, document review on a big case as her full-time assignment. Although she's extremely hardworking, believe me, she found the demands on her time excessive, including emails at 2 a.m. She left after 8 months. The second attorney, who worked for a firm here in town, returned to work on a reduced schedule after her first baby was born. But she found she was not, in fact, working less, and she did not see a long-term path to partnership. She left after the birth of her second baby. I was lucky, because that's when she came to work for me. The third, who stayed the longest, said to me, "When it comes to making partner, women attorneys and attorneys of color have the burden of proof. They have to prove their competence, while firms assume that white males will be leaders with no problems in increasing client contact." And all 3 agreed. The pathway to advancement is even harder for attorneys of color than for women. There are some bright spots. As women and attorneys of color leave firms, many are going in-house. And just as the story reflected, many are now moving up those ladders and demanding that firms include women attorneys and attorneys of color, and not just in document review. Also, it's hoped that male attorneys are becoming more interested in a balanced life, including more time for parenting, which may help to change firm culture. And more firms perhaps will adopt proposals such as those Paul Weiss adopted in the aftermath of the 2019 new partner picture, and reward partners' efforts to increase diversity and inclusion by paying greater attention to that and setting compensation. In addition to hopefully affecting changes in law firm culture, efforts are being made to increase the number of students of color in law school. Research from the Law School Admissions Council found that students starting in a 2-year institution, community college, who are often students of color, tend to succeed in law school as well as students who start at a 4-year institution. The challenge, however, is getting them to the point where they feel comfortable applying and having them apply with a real chance for success. In response to findings such as these, in 2014, the State Bar of California and California Community Colleges announced a program to increase the diversity of the legal profession. It's called the Pathway to Law Initiative. Students enrolled in this program in the community colleges will take 7 specified community college courses to improve their writing and critical thinking. They'll receive mentoring from law school advisors, LSAT prep, and a waiver of fees for the admissions process at participating law schools, which include USC, Loyola, and the UC law schools. And last, the crown jewel of diversity in California's legal profession, the state judiciary. In 2011, through the end of his second term, Governor Jerry Brown appointed 644 judges, more than 1/3 of all sitting judges in California. 44% are women, and nearly 40% identified themselves as non-white, according to the governor's office. Nearly 6% identified as lesbian, gay, bisexual, or transgender, all records for this state. For litigants, the benefit is to see courtrooms that are a fair representation of their state. And for for judges, it's an opportunity to learn from each other's experience. I have total confidence that this trend will continue with Governor Gavin Newsom's appointment of my friend, retired Associate Justice Martin Jenkins, as Judicial Appointment Secretary. With 30 years on state and federal courts at many levels, Marty is an EWQ, exceptionally well qualified to ensure that California continues to have a supremely qualified and diverse bench. Marty sees mentoring as perhaps his most important role. In my view, that will be a key advantage. Not only will Marty facilitate the application process for attorneys who are ready to serve as judges now, but he will also seek out and mentor attorneys who are qualified, but simply never envisioned applying for judgeships. Marty will mentor them and encourage them, and either during the time that he is the appointment secretary, or perhaps with his help even after, they will apply for and become judges. Marty has joined us tonight, and I'd like to ask him to stand and be recognized. And finally, I'd like to thank all those who are truly responsible for any success I've had. My husband of 51 years, Dr. Tim Collins. Our son, Tim Jr., is the Senior Vice President at DreamWorks Animation. Our daughter, Rachel, who's not here tonight, she's home with our 9-month-old granddaughter. And you've met my brother, Bruce, who's here tonight with his significant other, Judge Monica Benton, retired. And I'd like to thank my colleagues, past and present. You've met Presiding Justice Lee Edmond, who, as she said, is so helpfully right down the hall from me, and we really enjoy getting together to chat about matters legal and non-legal. And also here is Presiding Justice Nora Minella, who is both a former colleague on the federal bench and my current presiding justice. And also at our table, Carlos Moreno, who I think all of you know as Justice Moreno, Ambassador Moreno, and now with JAMS. And LA Superior Court Judge Rupert Birdsong, the past president of the Langston Bar Association. And lastly, I'd like to give a shout out to first my UCLA Law School classmate, Sharon Baumgold. And I'd like to thank all of the other judges who are here tonight for attending and ask them to stand. Again, I'd like to thank the Beverly Hills Bar Association first for honoring me with the Ronald George Award for Judicial Excellence, and secondly, for awarding scholarships to economically disadvantaged law students with a commitment to public service. Thank you.
we're going to turn to the Excellence in Advocacy Award and our very deserving honoree, Kelli Sager. Kelli is known for her prowess as a First Amendment lawyer, and we're fortunate today to have two amazing speakers on her behalf, Jeff Glasser and Carleen Goller. As General Counsel of the Los Angeles Times and San Diego Union Tribune, Jeff Glasser handles newsroom counseling, litigation, intellectual property, employment, contract, and commercial matters, privacy, compliance, and a variety of other legal issues. He also represents these publications in legislative and policy matters in California and in Washington, D.C. Jeff is a board member and chair of the Government Affairs Committee for the California News Publishers Association, co-chair of the Media Law Resource Center's California chapter, and a member of the Legal Affairs Committee for the News Media Alliance. A graduate of Yale University, Jeff received his law degree from the University of California's Berkeley School of Law. Carleen Goller is a practicing First Amendment lawyer who teaches media law at the University of California Irvine School of Law. She opened her own law office and serves of counsel to Jassy, Vic, and Carolyn after having spent nearly 25 years as a First Amendment counsel, newsroom lawyer, and the sole content counsel for the Los Angeles Times and all of the Los Angeles Times Media Group enterprises. Today, Carleen provides deadline and long-term strategic business and legal counseling for newsrooms and content providers publishing on every platform, and for journalists, authors, poets, documentarians, and filmmakers to mitigate liability for defamation, invasion of privacy, right of publicity, copyright, and trademark matters. Carleen defends global for-profit and nonprofit media companies, websites, startups, journalists, producers, filmmakers, and authors from prior restraints, pre-publication demands, post-publication cease and desist, subpoenas, and retraction demands. In short, everything that a newspaper might have to deal with. Ladies and gentlemen, please join me in welcoming Jeff Glasser and Carleen Goller.
Good evening. Remember back in 2008, back when we lived in a world that made some sense? If you'll recall the presidential campaign that year, one of the questions that Hillary Clinton asked voters was to consider who could responsibly answer the call in the middle of the night when there was danger in the world. She had in mind someone with experience, seriousness of purpose, judgment. Thank goodness we don't have to worry about that anymore. When it comes to free speech, this nation's founding and central idea, I can tell you firsthand who you want to answer that call. I know because I've made that call. It was 2002. I was out to dinner when my pager, yes, it was long enough ago that I still carried a pager, went off. It was the city desk. And the Archdiocese of Los Angeles had learned of a story it thought the Times was preparing to run the next day. It involved the Cardinal's emails to his special advisors regarding sexual abuse by priests. The Archdiocese somehow had arranged for a judge to open up the Superior Court in the middle of the night to hear its request for a prior restraint. As many of you know, there are few greater offenses to the First Amendment than a prior restraint. In fact, it was sort of like the rule of perpetuities when I first started practicing. Nobody had heard of there being a prior restraint on the press. Well, that changed. There are few greater offenses to the First Amendment than a prior restraint, which seeks to squelch speech before it is spoken. So here we were. Los Angeles' most important religious organization was seeking to silence its most important newspaper. And it had found a judge willing to entertain the idea. We were asked to argue now, that night. That is danger in the world, and certainly in the world where I live and work. My call was obvious. It was to Kelli Sager. I had been at dinner, but I knew I would find Kelli at work. She was drafting writ papers to fight another prior restraint against one of the Times court photographers in San Bernardino. She dropped everything and raced to the courthouse, and we found the door locked and had to bang on the window, like in The Graduate, to find someone to let us in. And we did. We arrived for the late night hearing flustered. At least I did. Kelli didn't miss a beat. She was smart and careful and unyielding. And in the course of arguing the motion, she and I even elicited from our counterpart the concession that a contested email in the case did in fact come from Cardinal Mahoney, as the Times believed, but didn't know. That's why they weren't publishing at the moment. But now we knew. The motion for the prior restraint was defeated. The email was authenticated. The Times stopped its presses while the reporter wrote the story with a really good editor, Jim Newton. And the paper published the next morning. That was the priceless demonstration of Kelli's superb abilities and coolness under fire, but it was hardly the only one. My years of working with Kelli have given me dozens, hundreds maybe, of chances to see her at work, to appreciate her unflappable cool and her passionate intelligence. One favorite of mine was one of our first. It was in 1994 in the midst of that era's trial of the century. Judge Lance Ito opened a hearing in O.J. Simpson murder trial by producing a stack of mail. He had it brought in next to his bench in the courtroom. And he told her and the public that the public wanted the trial closed on all the participants. Ito's mail, he said, overwhelmingly told me to pull the plug. And Kelli's response was perfect. She said, "My clients would be happy to organize a letter writing campaign if that's the way the court wants to decide this case." That was the last we heard of using mail as a legal argument. In fact, by the time that case was over, Ito was so conscious of press access that on one occasion he specifically asked for Kelli to argue so that he could make the best decision. But she was out of town. She was snowed in Telluride. She had managed to sneak away. But we weren't going to let that stop us, so we got a group together to fetch her. The Los Angeles Times, the New York Times, Gannett, Copley Press, CNN, ABC, NBC, CBS, Court TV, and KTLA, to name a few, combined forces to arrange for a private plane to pick up Kelli in that snowstorm and deliver her to Los Angeles and to Ito's courtroom the next day. She prevailed on that motion, too. I've learned a lot from Kelli. I've learned a lot about discipline and organization and effectiveness. I've learned even more about trust and admiration and friendship. And I've learned who I will call when it's 3 a.m. and there's danger to free speech. My call will always go to Kelli Sager.
I wanted to say at the outset that a lot of the people in this room have been mentored by Kelli Sager, and I certainly started out my legal career working for Kelli, and I owe her a lot in terms of learning attention to detail, in terms of making sure that a brief considers every single argument of the other side, in terms of tireless advocacy, and that can be 24-hour advocacy. And I know that there are a lot of people in this room also who owe the starts of their careers to Kelli, and she really has mentored a lot of people. And she started out 12 years ago, and I came into the law firm through the San Francisco office, and so she didn't know me. And I came into the office, and she said, "Oh, we should work on a project sometime." And now, 12 years later, we have worked on many, many projects, both as colleagues at the law firm and then as her client at the Los Angeles Times. I wanted to talk a little bit about prior restraints as well. Unfortunately, the Los Angeles Times had 3 prior restraints last year, which is pretty extraordinary. During the worst of those prior restraints, I was actually in Mexico, and it started on a Saturday morning in Mexico. It was my first wedding anniversary, and so I had left for a rare weekend away. And I made the mistake of looking at my phone very early in the morning. And sure enough, there was a reporter, and the reporter said, oh, you know, I've obtained this plea agreement. And the plea agreement shows that there was a corrupt cop from Glendale, and this cop was secretly tipping off the Mexican mafia about all sorts of raids that were going on and helping Mexican mafia members evade arrests. And I said, well, how did you get the document? And she said, oh, I just downloaded it from Pacer. And oh, by the way, there's this attorney and he tells me that I need to give it back. And I said, well, don't give it back. But what did I do? I went and I called Kelli. And I explained the situation to Kelli, and we both agreed that under a bunch of Supreme Court precedents that we had the right to publish this material. We hadn't done anything wrong. We had just obtained a document from the public court file from the Pacer system. And so we published our story about noon on Saturday, and we thought that was the end of it, but it really was not the end of it. And sure enough, we got a call maybe an hour and a half later that a federal judge had been found and had held an ex parte hearing without hearing from us, and had issued an order not only saying to reseal the record, but ordering the Los Angeles Times to unpublish the article that it had published. So classic prior restraint. You have to understand the context here. It's about 3 weeks of new ownership. There's a new editor. There's a new owner who doesn't know a lot about the media business. We have to then go, Kelli and I, and explain to the editor and the owner that there's this order, and if you defy this order, you could get contempt fines that are very serious, or even worse, you could end up like CNN, which had to apologize every hour on the hour for 24 hours for defying a court order when they published Manuel Noriega's surveillance video with an attorney where it had been leaked. So we had this very difficult conversation, and I was so thankful to have Kelli at my side during this conversation. And we convinced him that we were going to have to comply with the court order, but we also decided that with all due speed, we needed to try to get this unconstitutional court order overturned. So we decided to draft writ papers to the Ninth Circuit, as well as to do an opposition in the district court. This was in federal court. And by then, it was probably 7 or 8 o'clock. My wife is here. And Kelli, unfortunately, didn't have help. It was Saturday night. It was the summer. Her key lieutenants were away. And she said, Jeff, just don't worry about it. I will draft the writ petition. And she sat there and she drafted the writ petition so that I could go have my anniversary dinner with my wife. And that is who Kelli Sager is. She is a tireless advocate for the press and for the Los Angeles Times. Kelli obviously has a great record of success defending the Los Angeles Times and other media organizations in litigation, and also establishing and vindicating the public's right of access to records and to meetings. As many of you know, she was instrumental in the California Supreme Court's decision finding that there is a right of access to records and to proceedings in civil court in the NBC subsidiary case. She established that the names of police officers are public record in California in a case called the Post case in 2007. 7 years later, she established that the names of police officers involved in shootings are generally open to the public in the Long Beach Police Officers Association's case that went on for so long that I was the associate working on it at the law firm, and by the end of it, I was the client at the Los Angeles Times. She most recently last year got a published opinion in the Pasadena Police Officers Association case from the 2nd Appellate District that had a very important precedent for public records requesters in California, that established that when a third party like a public sector union brought an injunction and sought to stop disclosure of public records, and they lost, and the requester intervened and successfully advocated for public access, that the requester could recover fees under California's a private attorney general law, which was the culmination of almost a decade of litigation about so-called reverse public records lawsuits. She also helps us when we get in trouble. We, in December, got a published decision also from the 2nd Appellate District that recognized that we were privileged to report on an LA police investigation where we had an editor's note, and the editor's note in that case talked about a cartoonist who had also written op-ed pieces for us, and he had written that he was roughed up and mistreated during an arrest for jaywalking, and it turned out there was an LAPD police audio tape of the encounter, and it raised serious questions about his depiction. It seemed to be a polite encounter. We ran an editor's note. We ended up in this lawsuit for 4 years. The cartoonist actually personally sued the publisher, who's now the superintendent of LAUSD. And he also sued the LA Times and a bunch of other corporate entities. But the Court of Appeal recognized that this kind of speech was protected as a matter of law. As a result of that litigation, Kelli has ended up being caricatured by the cartoonist, who is upset repeatedly online. So you can look at the caricatures. They're not the most flattering caricatures.
Speech is speech.
Kelli did a master class in defending our former reporter, Robert Federucci, when he got entangled in the criminal trial of Sheriff Lee Baca a couple of years ago. At one point, Judge Percy Anderson literally sustained, I think, 10 objections in a row to questions that went beyond published information by the defense counsel in the first trial. And at the second trial, the defense counsel didn't ask any questions of our reporter. She is definitely the person that I would call anytime that I am in trouble, and I think she is a tireless defender of the First Amendment, and I'm so proud to congratulate you for winning the Advocacy Award.
So everyone's setting their clocks to, their alarm clocks to wake up in the middle of the night so they can call Kelli, who will be working at her desk, apparently. I'm pleased to now introduce Dan Grunfeld. Dan Grunfeld is our 2018 Excellence in Advocacy Award winner. Dan has spent much of his career combining his passion for law and public policy to improve the lives of and extend justice to thousands of at-risk individuals and vulnerable communities. Dan received his bachelor's degree summa cum laude from Drexel University and his JD from Cornell Law School. Dan became president and CEO of Public Counsel and later joined Morgan, Lewis & Bockius as the leader of the firm's West Coast litigation practice. He was subsequently named the first executive vice dean for strategy and partnership of the Rand Pardee Graduate School. Throughout his career, Dan has balanced litigation practice with an active pro bono practice. Ladies and gentlemen, to present the Excellence in Advocacy Award to 2019 honoree Kelli Sager. Please join me in welcoming last year's honoree Dan Grunfeld to present the award.
Thank you. Congratulations again, Justice Judge Collins, on a well-deserved award. So Kelli has been deserving of this recognition for many, many years. But I think it's especially appropriate that she's getting it this year, considering the times we live in. I've known Kelli for many, many years. We came out of law school 1 year apart. And I don't remember the first time we met, but I do remember the first time you had a profound impact on a decision of mine. And I would be scared too. Kelli just went. It was early in my tenure at public counsel. We were involved in a very, very contentious consumer law case. Our co-counsel was that schlocky law firm of Latham and Watkins. And it was, the other side was acting and behaving rather aggressively. And one Wednesday morning, I had the lead lawyer sort of rush into my office and start waving a piece of paper in front of me, and he said, "Have you seen this?" I said, "No, I've not seen this. What is it?" What this was this document, which was titled 6 Tips for Dealing with Public Counsel. It was posted on the web. It's a rather lengthy document. I won't even come close to reading all of it, but let me give you some excerpts. Say you get one of public counsel's standard letters accusing you of being the Antichrist. Goes on, do not, however, deal with public counsel. Another section. Unfortunately, the attorneys at public counsel apparently missed the lecture on evidence section 1152 when they were in law school. Another section. Understanding that you will be dealing with emotions and not rational thoughts. In many ways, public counsel lawyers are like zealots. Don't make the mistake of behaving that you can convert them with facts and rational thought, and so on, and so on, and so on. Now, as I mentioned, this was early in my career. I was going to make sure that my staff was going to be protected, that the good name of the organization would not be besmirched. And I was, and this is a litigation term, pretty pissed. And I called Colleen, and she said, "You need to talk to Kelli." So I went and talked to Kelli, and we did what we often did. We went and had drinks at El Cholo. So I had prepared the night before, and I had 27 different theories. They had used their logos. I came prepared with what I thought was a well-thought-out plan of attack against this infamous act. Kelli did 2 things. One, she sort of listened with this calm but bemused expression on her face. And the second thing she did is she put a margarita and a half in me. Now, this margarita and a half is important, okay? 1 would not have been sufficient. 2 would have gone to the point where my judgment may have been impaired. So 1.5 was about right. And as I was ranting about, we got to go and get a preliminary injunction, we got to go to the Superior Court, no, we got to go to the federal court, no, I got to go to the Hague Court for International Justice. The thing that I remember saying to her that I cringe to this day, at that time, we were co-counseling on a different case with the former head of the CIA, Jim Woolsey. And I actually said to her, again, cringing now, we should talk to Jim Woolsey. Maybe his former friends at the CIA can help us. She sat there, and then basically, once the margarita did its magic, said to me, a lot more politely than I'm about to put it to you now, just be quiet and chill. And she explained, completely appropriately and with much, much wisdom, that taking any of those actions will just reinforce the notion that public counsel was zealots. that that's not who we are, and that I just needed to chill out, which I did. And I got some of my board members to chill as well. And somehow, as you know, public counsel has survived this little piece of paper, thanks in part to Kelli Sager. Now, a short postscript. A couple of months later, we went to drinks again at El Cholo. I put a margarita and a half in her, invited her on the board, she accepted, and she ended up having an extremely distinguished tenure on public counsel's board and eventually the executive committee. But if Kelli made her first great impression on me by not taking a case, what should impress all of us is a case that she has handled. I don't have enough time, and Colleen and Jeff have done an amazing job. But if you have 15 or 20 minutes, just go on her website, on her law firm's webpage, and just look at those cases. They're phenomenal. They speak about what it is to be a lawyer, an important lawyer, in these times. You know, the thing about these dinners is that it's nice to get together and feel good and honor people who we like and respect for their work, for lifetimes worth of work. And it's especially nice with the Beverly Hills Bar Association because we always get fed so well. Mark always makes clear that of these type of dinners, nobody has better food. But every once in a while, these dinners actually become important. They become important because we honor judges and lawyers who stand for something beyond success. They stand for defending incredibly important propositions about what it means to live in a democratic republic. And tonight is one of those nights. When we honor Kelli Sager, what we say to the community, what we say to the public, and what we remind ourselves is this is why it's glorious to be a lawyer. These fights really matter. This is what excellence looks like. Not carved letters on the wall of the Supreme Court, but real flesh and blood. People like Kelli getting up at 2 a.m. because they need to fight for the First Amendment. That's why tonight is so important and why I'm so gratified to be here. So this time, unlike last year's fiasco, the Beverly Hills Bar Association nailed it by honoring Kelli. Please get up on your feet and honor Kelli Sager with the Excellence in Advocacy Award.
Well, I'd like to thank the Academy. Oh, sorry, wrong event. John Rubiner did tell me that this was sort of like the Oscar for the legal community, and it does sort of feel like that, being in Hollywood with this beautiful ballroom and all these great people. And I'd like to thank the Beverly Hills Bar Association and everyone at the association for selecting me to be the honoree this year for the Excellence in Advocacy Award. It's like winning an Oscar in another way, too, and that's because there's a long list of people that have made it possible for me to be here today. So before I get to my substantive remarks, I hope you'll indulge me for just a minute while I acknowledge a few of those people. I'd like to start by thanking Dan Grunfeld for that lovely introduction. It's such a privilege to follow in Dan's footsteps in getting this award. And thank you as well to Presiding Justice Lee Edmond and to John Rubiner for their kind comments. To Carlene Galler and Jeff Glasser, thank you so much, both for those lovely introductions and for your support and friendship over a period of many, many years. It's been a great pleasure for me to know you and to get to work with you and all your colleagues at the Los Angeles Times, present, past, and future. Now, as an aside, I have to mention that my very first court appearance as a lawyer, one day after I was sworn into the California bar, was for the Los Angeles Times. And Jeff Klein was then the newsroom lawyer, and I'm very pleased that Jeff and his wife are here tonight, and thank you very much for being here. It's been more than 3 decades, and I'm honored to still have the privilege and honor of representing the Los Angeles Times. And I want to thank all of you for being here tonight. It really is overwhelming. I'm not often at a loss for words, but if I hadn't written it down, I wouldn't be able to get through a speech tonight. My 2 sisters came down from Washington State, which means a lot to me. Cousins from Northern California are here. Friends and colleagues from the East Coast and from the Northwest who swear that they came because of the event and not because the weather is just horrible in the Northeast and Northwest. But I've been really fortunate during my career to get to work with some truly exceptional lawyers. In-house people that are incredibly talented and also have become really good friends. Some lawyers at other firms, we won't mention the firms, but I've worked with them side by side to defend First Amendment rights, and we've also become very close friends. And my friends and colleagues from Davis, Wright, Tremaine, including the team of lawyers I have the pleasure of working with on media matters every day, and I'm greatly honored that all of you are here tonight. I'd also like to thank my husband, Steve. If you've seen the movie RBG, you might have been struck as I was by the depiction of Justice Ruth Bader Ginsburg's husband, Marty. By all accounts, Marty Ginsburg was a brilliant lawyer in his own right, who was a steadfast supporter of his wife's career, even at the expense of his own. And like Justice Ginsburg, I'm incredibly fortunate to have a husband who has been my steady supporter and sounding board and confidant. So thank you for that, Steve. And you deserve that. And finally, but certainly not least, I would like to thank Justice Audrey Collins. It's an honor for me to share the marquee with someone who I so greatly admire and respect. Someone who is not only a talented jurist, but as you've heard from others, is one of the nicest people you will ever meet. In 2002, Justice Collins was serving as a federal district judge, and I appeared in her court a number of times. And then I got a call from her asking me if I would be interested in being a lawyer representative for the Central District. I'd never heard of lawyer representatives. I had no idea what they did, but I knew enough to know that if Judge Collins was asking me if I wanted to do it, the answer was yes, I would do it. And thanks to her, I've had the pleasure of working with the Central District and with the Ninth Circuit judges for the last 17 years in a variety of contexts, and it's been one of the most rewarding and enjoyable things I've gotten to do in my professional career. So I thank her and owe her a great debt of gratitude. Her nomination of me was just one of the many things that she has done to try to improve diversity in the legal profession. Lawyer representatives had tended to be mostly senior male white partners from big law firms, and she continued those efforts then and to this day, as her remarks have indicated. So in keeping with those sentiments, I'm greatly honored to be the first woman to receive the Beverly Hills Bar Association's Excellence in Advocacy Award. As John Rubiner mentioned, I have to admit, when he called me about this award, that I would be the first woman selected, I was surprised. In my more than 30 years of practice, I've known a great many extremely talented women litigators who are at least as deserving, if not, frankly, more deserving than I am of this award, including some of the women who are in this room tonight. But as I thought about it, I realized that there has been a kind of a disconnect between the perception of the skills you need to be a good litigator and the perception of women in our profession. Now, for me, litigation always seemed like a natural fit. When I was 3 years old, and this is a true story, my mother wrote a letter to her sister that said, in part, quote, "God gave Kelli talkathon vocal cords, and she isn't one to let a moving part rust from disuse. But she can amuse herself pretty well. She keeps right on talking whether there's an audience or not." The associates were laughing a little too hard at my table, but she later wrote, "Perhaps she'll become a lawyer." When I was in 9th grade, the debate coach from the high school came to visit our class, and he said, "If you like to argue, you should join the debate team." And all of my classmates turned and pointed to me. So I did. I debated all through high school. I debated through 4 years of college. Most of my college debate friends went on to law school, and so did I. But when I showed up for the first day of law school with my hair pulled back in a ponytail, one of the young men in my class said, "Oh, look, Gidget goes to law school." And when I interviewed for a summer job at one of Los Angeles' largest firms and expressed an interest in being part of the litigation group, I almost didn't get hired. One of the partners in the employment group who interviewed me wrote a review that said he thought that I was too, quote, edible, close quote, to be a litigator. Fortunately for me, one of the associates who was on the summer hiring committee had been one of my opponents when I debated in college, and he assured the litigation group that I was plenty tough enough to litigate. But on the opposite end of the spectrum, exhibiting those kinds of traits that are often viewed differently for women than men, there can be a kind of subtle misogyny in the language used to describe male litigators and the words used to describe women who exhibit the same behavior. It's not unique to the legal profession by any means. In 2014, Fortune magazine's website published a study of the tech industry specifically focused on performance reviews. It came from 28 different companies, varying sizes, and the reviews came from both men and women, roughly 180 people. As the article reported, one word appeared 17 times in reviews of women and never in any of the reviews of men, the word abrasive. Other words were disproportionately used for women, including bossy, aggressive, strident, emotional, and irrational. The word aggressive did appear in 2 reviews of men in the context of them being urged to be more aggressive. Reviews of women only ever used the word aggressive as a criticism. I was reminded of this study and several like it last year when one of our clients received a legal threat from a fairly well-known plaintiff's lawyer who has his own sort of aggressive style. His demand letter was typically hyperbolic, and the response from our office denied that there was any basis for a claim and said that if they pursued a lawsuit, our client would seek to recover the cost of defense what it viewed as a meritless lawsuit. I was lead counsel, so the letter went out under my signature. The email I received back did not mention the merits. Instead, the opposing lawyer wrote that my letter was so, quote, strident that he and his 2 male colleagues who were copied on his email felt compelled to, quote, suggest that I reflect on how I come across. I have no doubt that a letter written by one of my male colleagues would not have gotten the same response. But the funny thing about it was that the letter was actually written by one of my male partners. He had not yet appeared in the case, and so the letter went out under my name. All of this is kind of a long way of saying that to achieve diversity in the legal profession, including among litigators, we need to be vigilant about recognizing and addressing these kinds of subtle or perhaps not so subtle biases. I commend the Beverly Hills Bar Association for recognizing that women are advocates, litigators, trial lawyers, and I am very appreciative to have been chosen for this honor. So in the few minutes I have left before they start playing the music and they pull me off stage, I wanted to mention one more reason why this award is so meaningful to me, and it involves the person for whom this dinner was originally named, and the award presented to Justice Collins is named for Chief Justice Ronald George. As has been mentioned, much of my work over the last 30-plus years has involved the rights of the public and press to have access to court proceedings and court records. For better or worse, no matter how many cases I handle in the course of my career involving all kinds of issues that affect media and entertainment companies, I will probably always be best known as the lawyer who represented the media in the O.J. Simpson murder trial. Sadly, the media lawyer part somehow didn't make it into the FX series, and it didn't make it into the ESPN documentary. Jim Newton, however, is featured prominently, and I recommend that you see it because he's excellent, but I didn't make it in. But my work during the Simpson trial largely focused on the rights of the public and press to observe and attend judicial proceedings. And most of you are familiar with the background of where those rights come from. The framers of our Constitution were fearful and distrustful of star chamber proceedings that had led to great abuses in England and in other countries where secret things happened behind closed doors. They believed that only an open system could truly achieve justice. So the Sixth Amendment to the Constitution gave criminal defendants the right to a public trial. But it didn't mention directly anybody else. But the U.S. Supreme Court later recognized that the Constitution also provided the public and press with the right of access to criminal proceedings under the First Amendment. They realized that for the public to feel confident in the result of a criminal proceeding, and for there to be any true check on judicial power, that the proceedings had to be open so that, quote, all who care to observe could attend. Only a compelling government interest can justify closing a criminal trial. It's a very hard standard to meet, and rightfully so. But although the court hinted that the same presumption of openness should apply to civil court proceedings, they didn't ever directly address that issue. But in 1999, as was mentioned earlier, Chief Justice Ronald George wrote for a unanimous California Supreme Court that the same First Amendment principles that give a presumption of openness to criminal court proceedings applies with equal force to civil court proceedings. This was another case involving a celebrity. In that case, it was Clint Eastwood and Sandra Locke and their palimony trial. The trial judge closed the courtroom whenever the jury wasn't present, which meant that the public and press could not see any of the legal arguments between the lawyers that the court was hearing, or know what evidence was being discussed that was not going to be presented to the jury. The Los Angeles Times and KNBC objected, and the case ultimately wound up in the California Supreme Court. At this late hour, I won't go into all the details of Chief Justice Ronald George's 40-page decision, which explains all the historical and public policy precedent that justifies giving First Amendment protection and access rights to civil court proceedings. But among other things, his decision recognizes that just as with criminal trials, the public has to have faith in the outcome of court proceedings that adjudicate really important interests, not just about money, although that can be very important, but also about civil rights, voting rights, family rights, environmental rights. Justice Brandeis said famously years ago that sunlight is the best disinfectant, and that's every bit as true in civil court as it is in criminal court. The landmark decision has been cited by other courts across the country more than 160 times, and of all the work I've done, it is the decision of which I am the most proud. The principles it stands for are even more important today. In a political environment that is, shall we say, sharply divided, to say the least, the courts are where the public turns for fairness and impartiality. And the public will not trust the process or believe in the integrity of the result if it's done behind closed doors. As the number of journalists covering the courts has dramatically declined in many journalistic areas, it's the responsibility of judges to ensure that the rights of access are protected. In the wake of the Eastwood decision in 1999, the California courts adopted a new set of rules that prevented parties from stipulating to have things done in secret, which had often been the case before. They require judges to carefully adjudicate the constitutional requirements before documents can be sealed or before proceedings can be closed. That's critically important because often at least one side, and sometimes both sides, would prefer that a case never see the light of day. But when the parties are next-door neighbors, or whether the parties are the former chairman of a major political party, shall you say, and his alleged mistress, the public needs to know that the process is fair and that the result, whether it's a celebrity defendant, the wealthy, or the poor, the result is not going to be different and people are not going to be treated differently. And although the media now includes all kinds of digital publishers that didn't exist decades ago, the importance of allowing public access to court proceedings and records has not changed. If anything, having accurate information about what happens in our courts is even more important today than ever. It's been a great honor for me over the past 30-some years to represent journalists in helping to ensure access to court proceedings and records, and it's a great privilege to me to accept this award tonight on their behalf. Thank you.
Thank you again, all of you, for coming tonight, keeping with our newsprint theme. I encourage you all to take home a copy of the Daily Journal, which is waiting outside. Hope to see you all next year at our annual Litigation Awards dinner. Please drive home safely. Good night.